Okay, I'm going to call this meeting to order, the meeting of the Property Standards Committee, Monday, June 12th, 2023. The time is 12:02 p.m. The first order of business is to ask if there are any disclosures of pecuniary interest with any of the agenda items today. They're all training items, but okay, thank you. And I will now turn the meeting over to the Chief Bylaw Enforcement Officer, Rob Kennedy, who will address committee with a presentation and also talk to you about some rules of procedure. Thank you.
Good afternoon, committee. Just today, as Ms. Hollows has indicated, we're doing a little bit of training on the Property Standards Committee since everybody is new to this. So this will be more of an abbreviated training session. It'll run you through some of the rules and procedures that we'll go through when we're doing hearings, as well as I'll run through more of a kind of a mock situation, which we will get into next month, as we do have a couple appeal requests that have come in the last couple of weeks. Next slide, please. So first we're going to talk about how and why orders are issued, and then the submissions of appeals, process of the appeal hearing, committee powers, and then appeals to actual committee decisions. Next slide. And again. So how do we get to where an appeal goes? First, staff obviously will receive a complaint regarding any type of property standards issues. Mainly it's regarding either the exterior of a yard, more or less a clean yard situation, or it could be a situation where we have some issues with the building itself or buildings based on the condition of the buildings. Mainly property standards does deal with cosmetic issues, but there are times where there are some structural issues that in conjunction with the building department, we will deal with those through the property standards bylaw. Once we open a file and start the investigation, we conduct a site visit and determine what, if anything, is a contravention of the property standards bylaw. During that site visit, we look at everything on the property. So for example, if we get a complaint in regards to an exterior yard just being unkept or unclean, the way property standards works is when we get to that property, we need to look at everything in regards to the property standards bylaw. So even if the building wasn't part of the issue that was at hand, we will also look at the building to ensure that it does comply with property standards. And the reason for that is if we go to a property and we overlook something in that sense, there is a bit of a liability issue that comes to the township, because the question could be, well, you should have seen that and why didn't you deal with it? So at that point, that's why we deal with everything when we get these types of complaints. We look at this in regards to the property standards bylaw and under the Building Code Act, which is where property standards bylaws get the authority from. Next slide. When we're there, we take photos of all the contraventions. Our main goal is to essentially take a photo of the whole property if you can, and then you single in on the contraventions. So we log everything in our notebooks in written format and electronically for record keeping, which is through our Lisa system. And then if we do have to lay an order to remedy, the authority, as I said, comes under the Building Code Act of Ontario. If you wish, I'm not going to go through it today, but the authority that we gather everything from is through Section 15 of the Building Code Act of Ontario. And then once we find the issue, we issue the order, then the process starts in regards to appeal rights and deadlines. Next slide. So what's in an order? Through Section 15.2, subsection 2 of the Ontario Building Code, it specifies which details have to be included in the order. If these are not in the order is not valid. One is we have to obviously state the municipal address, and the option is there for the legal description of the property. In that respect, another best practice is actually having the property identification number also included on that order. We have to give reasonable particulars of the repairs, or if there is a removal or we're asking for a demolition of a building, those need to be in the order. We have to indicate dates of compliance, essentially deadlines for all the contraventions. There is a minimum requirement of 14 days. Again, best practice, because in the past, the Building Code Act did not allow for email service. So there was always registered mail service that needed to be done for these orders. And in that respect, they always wanted 5 days. So essentially you get 19 days for the order to be appealed. But with updates to that legislation, there has been abilities that if we do email the order to the person, if we have the last known email address, then it does drop down to the 14 days, as through legislation again, once the email is sent, that is deemed served. The last thing is we have to give a final date for the appeal, which, as I just said, would be 19 days from the date of the order. Next slide. So getting into the actual appeal, when we issue the order, everybody has the right to appeal. So long as they submit the appeal within the time frame, the committee shall hear the appeal. There is no option to not hear it. If someone does appeal, the committee has to hear that appeal. If the appeal is submitted after the deadline, staff would then bring forward the request to the committee, and it would be up to the committee to decide whether or not they wish to hear the appeal. Once the appeal is scheduled, this is in regards to site visits. Committee does not have the right to enter onto the property like officers do. So I would recommend, if you wish to get kind of a view of the neighborhood and get an idea of where the property is located and what's around it, you're more than welcome to do drive-by inspections of the property. 9 times out of 10, you're going to be able to see everything from the road anyway. So that is well to do, but there is no right to entry onto the property for committee members. Next slide. So going through a process in regards to an appeal hearing, it's more of a quasi judicial hearing. And while it's informal, we still have to follow the Statutory Powers and Procedures Act. Upon the commencement, sorry, just going to flip my phone here so I can read it. There we go. So upon the commencement of the hearing, staff or our representative, which would be our legal representation, often not, if we do choose to go that route, it would most likely be our municipal prosecutor, which is Jean Polak through Barriston Law. And we would detail our presentation or evidence, if you will, to the committee. That will be done through a report, which will have all the particulars of the contravention, a copy of the order that was issued, all photos that we have taken, and any other evidence that we wish to put on the record in front of committee. Committee and the appellant are then given the opportunity to ask questions of staff through the chair. The only questions that can be asked are through the information that was given by staff or our legal representation. So in that respect, they can't ask a question about something that hasn't been presented in evidence. After that, the appellant will then present their evidence that they wish the committee to see. And then again, after that, both staff and the appellant that they have been heard, committee may ask questions of any party in the appeal, which would be the officer that issued the order, the appellant, or agents that would be representing either party. Next slide. The appellant will then present their evidence that they wish committee to see. I think I already said that. Sorry. So then committee, after that situation and that process is passed, there's 2 options that committee has, which is a little bit different than most committees that you'll see, such as Committee of Adjustment, where you are able to discuss the matter in open session, or if you wish, you can suspend the meeting and deliberate in private amongst yourselves to make that decision. So that is the uniqueness of a property standards committee, is that you guys are allowed to in a sense, go into a closed session and deliberate, much like you would see like a jury would do in a court case. Next slide. Once the decision has been made, the committee chair will then render the decision to everyone present. And if possible, a written decision would be served to the appellant at the time of the hearing. Now, with virtual hearings, or if someone is coming in through Zoom, obviously that would be virtually impossible. So a written decision would have to be sent in writing, sent by regular mail to the appellant. Next slide. And again. So going through the Property Standards Committee powers, there are 4 different options for when making a decision. One would be to confirm the order as issued. So that would mean that there are no changes to the order, and that would be what staff would be recommending in every single case for property standards. We would always ask that the order be confirmed. Number 2 is modify the terms of the order. So that would be if you wish to delete anything from the order. It may be by the time you get to the appeal that some things have been resolved already and that doesn't need to go forward. Number 3 is you can quash the order. This would be done in a sense if you felt as a committee that the order was issued not in compliance with the act, or if you don't feel that the order was necessary in the first place. That would be something that you would be able to decide. And number 4 would be extend for the time limit of compliance. So a lot of times in my experience, number 4 is usually the decision that is made. Well, again, staff always wishes that the order be confirmed. There is some level of compassion, if you will, to certain situations. So a lot of times I do see that the committee does extend the time limit that is given for compliance. Next slide. So the question that usually comes up is, can committee remove or add items into the order? Can you remove? Yes, you can. As I already said, if they've been complied with and there is no longer an issue with that certain item number, then committee can take that out of the appeal. However, if committee asks the question to add something, unfortunately, that is not able to be done. 1, because it would require a brand new order to be issued, and 2, the committee doesn't have the power to add things onto the order, as they don't have the same powers as what a property standards officer does in that situation. Next slide. So after committee makes a decision, there is another appeal body, which would be the Superior Court of Ontario. Either party is allowed to appeal to Superior Court. Very rarely have I ever seen a municipality, or for that matter, an appellant appeal to Superior Court. It is quite costly. So those appeals would have to be submitted to the Superior Court within 14 days of the decision of committee being sent. And if the appellant is appealing the decision, they shall provide notice to the municipality of their appeal. So just keep in mind when you are making these decisions that these could go to Superior Court. There are a bunch of case law that, again, I won't get into today. But if you wish, at your own leisure, you are able to look. There's a website called canlee.ca that shows a lot of these appeals. And if you wish for further information on those, I'm more than happy to provide those. Next slide. I guess that's it. So in conclusion, again, this is very short, but that's just a gist of what an appeal is going to go through. If you wish for me to run through this again, kind of in a little bit more detail, I'm more than happy to do, but I'm open for questions if committee has any. And I will say that next month we do have 3 appeals that will be heard, 2 of which will be the same owner, and the 3rd will be a different owner. Thank you.
So will we, similar to what we get now, will we get some notice of what and some info prior to the meeting?
Yeah, through in that sense, we will do the same as what we do for essentially what you would see through Committee of Adjustment or any of the other committees through council, where we will submit a report. It will go on the agenda with all those photos, all the evidence that we are going to submit through the Property Standards Appeal Committee will be done through the agenda.
Rob, is there third-party ability to have input into this, or is it strictly the appellant and the township at this point?
There is an ability if someone wishes. These are public meetings, so anybody in the public is able to speak if they wish to do so. If someone from the public does wish to do that, they are open to questioning from committee as well.
And in your, I don't know how much experience you've had in this, but if we are dealing with an agent, would it, the appellant, would it usually be the appellant, a planner, lawyer, or any combination of the three?
It can be a combination. In my experience, I actually haven't had anybody be a representative for someone. I do suspect the ones next month will most likely have representatives through by way of a paralegal. That is unknown at this point, but it's a strong suspicion of mine that two of the three will have paralegal present their evidence.
And I guess there's no way of knowing yet, but I think that the bylaw, your department have been busy at work and lots of backlog. So are we going to find that what might the expectation be for appeals or people coming in front of us by, I guess, by numbers?
Quite frankly, this doesn't happen too often. Anywhere in any municipality, you know, there's always going to be a few appeals. I think 3 in 1 month is quite a lot, to be honest with you. I think in the last term of council, there was maybe 1 or 2, if that. So these don't happen very often.
Can you just give a sense of, if I understand this correctly, if somebody has, 18 old washers and dryers in their yard and 10 old beater cars and a whole bunch of junk, and you go in, the neighbor complains and you go in and you write them up, and then they come to appeal. What are they appealing exactly? That they should be entitled to have all this miscellaneous garbage in their yard and that's their right? And is that kind of the way this goes?
I find a lot of times people come to appeal to get more time. Sometimes they don't feel that the deadline that we've issued is sufficient enough for them to clean up or fix items. Sometimes I have seen instances where they will actually make a legal argument on whether or not it's actually a contravention of the bylaw. I will say, like, our property standards bylaw is a 1999 bylaw, so it is a little outdated, but it still does work. It's one of the bylaws that we're looking to update in the future. But again, I think a lot of times, at least in my experience, I've seen people come in and they're simply just looking for more time.
They're not disputing, other than if they believe that they're not in contravention of the bylaw, they're not disputing what you guys are saying.
Yeah, again, my experience is more or less just they're looking for that extra time. I've had, I think, one instance in my career where someone has actually tried to make a legal argument, which was unsuccessful, and kind of along the same lines as what you just said, that people were trying to make an argument that they had use for the items that were in question, and they felt that it wasn't junk. Meanwhile, the property standards bylaw said otherwise.
I didn't understand what I was coming to, so.
It's a little difficult to do a training on the spot like this.
No, this was great. What I wondered is what happened before? How come we're doing this now?
Well, the Committee of Adjustment members are new to the Property Standards Committee. So last term of council, we had a full slate of different people that dealt with this, but in normal practice with a lot of municipalities, the Committee of Adjustment are also fence viewers and the Property Standards Committee on top of that. So doing these kind of informal training sessions, if you will, is just more or less an introductory of what's going to happen in the future. We're doing this month because we have received 3 appeals, which will be heard next month after the Committee of Adjustment date in July. So that's why we wanted to kind of bring this forward so that you guys understand what the actual process is. Again, if you wish to have more information, I can give you kind of a rundown of what happens in a little bit more detail. But yeah, this is kind of why we're doing this, is because we have the appeals coming forward next month. So rather than you guys going into this totally blind, at least you have a little bit of information to go on when we get to that point next month.
And for staff at the time, we'll have you or one of your other officers to how it will unfold.
In next month's situation, I was the officer that issued all 3 orders, so it'll be myself presenting the evidence, showing the photos of what's at the property.
Okay, thanks, Rob. Just hang tight in case some other questions arise.
So other than just,
Sorry,
so other than reading the property standards bylaw, there's really nothing else that we need to prepare for in terms of this.
I think the only thing I would recommend aside from the property standards bylaw would be just brush up on the section 15 of the Building Code Act. That's where it's really spelled out in detail about what the appeal procedure is like, how people can make appeals, how orders are issued, different types of orders, because there are different types of orders, such as emergency orders or orders where we're wishing to have the owner give an engineer's report. So there's 3 different types of orders through property standards that we can issue. But that would be another thing to look at, is section 15 of the Building Code Act of Ontario.
Thank you.
Okay, thanks, Rob. That's great. I appreciate this. We also included on your agenda package the rules of procedure. And it gives a little more detail around much of the material that Rob has just presented. These rules of procedure were passed by the previous Property Standards Appeal Committee and are satisfactory to carry on forward. We have a couple of other items of business that we need to attend to before we adjourn. The first of which is to appoint a chair for the Property Standards Appeal Committee, and that would be appointed by the 5 of you, and that chair would be one of the 5 of you. Just to give you some comfort, as chair, we do provide you with a script and with a step-by-step procedure to follow during the meetings, but basically you would be in charge of the meetings like you would be chairing any other meeting of the township. So I'll just leave that with you now. If you want to think about that and come up with somebody, that'd be great.
Is there a volunteer among us? I can volunteer this. I cannot chair. The meeting would be chaos. I've been told that.
Okay, I'll read a resolution, and then once you pass it, then I'll. So moved by Member Brown. Oh, seconded by Member Stokes. I'm going to change that to Member Bridgman. Be it resolved that Sean Stokes be appointed as chair of the Property Standards Appeal Committee. All in favor? Okay, carried. Thank you. The second piece is to appoint the secretary of the Property Standards Committee. That's traditionally staff, and it's traditionally the deputy clerk. And so that's traditionally me. So I'm going to give this to Member Stokes to read. No, just read it,
Oh, read it.
please.
Be it resolved that Cheryl Hollows be appointed as Secretary of Property Standards Appeal Committee. Oh, sorry. Moved by member Quinn, seconded by member Edwards. Be it resolved that Cheryl Hollows be appointed. Oh, member Edwards, yeah. It's okay. Okay, so moved by member Quinn, seconded by member Brown, that be it resolved that Cheryl Hollows be appointed as Secretary of Property Standards Appeal Committee. All those in favor? So do you want me to mark those, tick those down and sign this?
Yeah. Future Americans go, see, he's gonna have one of those things on all lemons.
All right, moved by member Grogan Green, seconded by member Brown. Be it resolved that the Property Standards Appeal Committee adjourn at 12:28 PM. All those in favor? Oh, yeah, the yeas have it.